For judgment item number 1, JCRL 96 of 2006.
The appeal is dismissed. The bail bond of the appellant is cancelled. He is directed to surrender forthwith and in any event not later than 1st June 2020.
Item number 2, WPC 15796 of 2008.
The petition is allowed. No orders is to pass.
Item number 2, STREB 276 of 2008.
The revision petition is disposed of by answering the questions in favor of the petitioner and against the department.
Item number 4, ITA 68 of 2009.
So the one question number 1 has been remanded to the CITA for being examined afresh. The appeal is disposed of.
For mention.
Not even 26 September.
During that, no coercive action, my lord, only
Whatever is there, sir, same.
oblige.
Supplementary list item number 6.
Wait, please. My lord, this matter challenges the order under section 148A subsection D. Your lordships have issued notice and granted orders in a batch of writ petitions which is coming up on 29th June.
All right. So list on 29 June, interim orders to continue. All right.
Interim orders, my lord, sir.
To continue, I've said.
No, this is a fresh, this is coming up.
Oh, notice, then no coercive steps till the next date. All right.
I'm
29 June.
My lord, I'm passing on the similar order.
All right.
I'm
All
not even.
What about the next one also?
Item 7.
Next one, my lords, is a different issue. Lordship, this challenges the proceedings under section 153C of the Income Tax Act, my lords, on the ground, my lords, that there is no satisfaction note. Why I say so, my lords, is when during the proceedings under section 153C, when we inquired from the assessing officer that please give us the satisfaction note. Your lordships, if I may seek indulgence of your lordships to take up the second sub-item in this list.
Anyway, notice is not gone in this.
The fresh matter, my lords.
All right. You just
Let
say
him file the
notice.
appeal, my lord, the appealable order.
Oh, this is an assessment order?
Yes, my lords.
Yes.
But, my lords, it is completely devoid of any satisfaction note. That is why,
But that can be argued in the appeal.
yes, my lords, I raised all these points. These points were raised before the assessing officer.
No. You can argue this in appeal, I said.
My lords, so the thing is that, my lords, your lordships knows, my lords, it's very where it is patently without jurisdiction. And that, my lords, is when there is total absence of satisfaction note.
No, all those are grounds in appeal, sir. Those are grounds in appeal.
My lords, there is, my lords, may I just indicate, your lordship may kindly, my lords, give me a couple of minutes. Let me make my case. Your lordship may decide thereafter.
All right.
My humble submission, my lords, is that there was a search in relation to a particular search person, Sunaina Metals.
Correct.
Now, my lords, in that search, what was required? That search, my lords, happened on 3rd of December 2020. Your lordships has the second sub-item. Your lordship may have page 18 for a moment.
Yes.
Now, my lords, as per the standard procedure, what they do now, the income tax department, when there is a search, what they do first, they centralize the assessment. All the group cases they take and they assess it before one particular officer.
Correct.
Now, my lords, here the 127 order, the order for transferring or for centralization, my lords, is at page 18, which your lordship will see for a moment at page 20. Para 4, as per instruction of CBDT dated such and such, all the search and seizure cases and survey cases are required to be centralized with central charges. Therefore, for coordinated investigation and expeditious assessment of aforesaid, 39 cases are required to be centralized with DCIT Central Circle, Sambalpur. Now, my lords, we'll see the table. Point number 2 is where I am mentioned. My name is mentioned. Your lordship will see the assessing officer from whom it was transferred. ITO Ward 1, RKL, that is Rourkela, my lords. 2, DCIT Central Circle, Sambalpur. Now, my lords, thereafter, my lords, on the basis of this centralization, notice under 153C was issued on 22nd November 2021, which is at page 22. This is the notice. My lords, may kindly note the date 22/11/2021. So, my lords, my humble submission is the decision to assess me under 153C, that is something that must be taken by the original assessing officer of the searched person. That decision was not taken, and therefore, my lords, no satisfaction note is recorded. Your lordship will see another important aspect. There is a CBDT instruction, my lords, of 17th September 2020, which says when shall centralization take place, which has been relied upon, my lords, in the centralization order. The lordship will see serial number 2. Next page, my lords, serial number 2. Cases pertaining to search and seizure. Assessments in search and seizure cases to be made under 153A, 153C read with section 143.3 and also for the return file for assessment year relevant to previous year. Now, we'll see the next column is relating to assessment proceedings to be conducted by whom. It says the cases falling under section 153C, if lying outside central charges, that is beyond central circle, shall be transferred to central charges of the act within 15 days of issue of notice under 153C. 143.2 for compulsory selection. Now, we'll see the 143.2 notice was issued on 20th January 2022 at page 28 of my brief. So, centralization is to be preceded by a 143.2 notice. Here, centralization has happened in July 2021. 143.2 notice has been issued in January 2022. It is clearly in violation of CBDT's own instructions. Not only that, when there was a question posed by me, the assessing officer if your lordship will see at page 29, lordship, page 29, the assessing officer gives his explanation in relation to the satisfaction note. Here, I am challenging the 153C notice itself. That itself is illegal. We'll see para 5. Further, in this context, it is also pertinent to know that it is now well settled position of law that there is no need for any specific satisfaction needed for the purpose of invoking 153C as held by the Honorable Supreme Court in Supermall's case, wherein Apex Court held that if the AO of the search person and related persons are the same, there can be one satisfaction note prepared by the same if he records satisfaction on the basis of materials available on record and that document contains information of transaction which pertains to other persons, the same fulfills the mandatory requirement of section 153C. So, the assessing officer in this case says that the AO of the searched person and the related person are the same, which is not the case, Here, AO, of the searched person was ITO Ward 3 Rourkela and subsequently DCIT Central Circle. So, recording of satisfaction, has to happen at ITO Ward 3 Rourkela of the searched person. Now, related party, I am related party. My assessing officer is ITO Ward 1. So, it is not the same. So, that's why I say, there is no satisfaction note in this case. And it also, as I said, it is in violation of the CBDT instructions. Your Lordships, when there is patent lack of jurisdiction, in the case of Radhakrishnan, your Lordships knows where it's exception in the availability of an alternative remedy. The exceptions to the rule of alternative remedy is where the jurisdictions is completely not there. So, since absence of satisfaction note, there is no jurisdiction. Therefore, may kindly, I pray, your Lordships have the jurisdiction to interfere in this matter.
All right. You say the challenge in these writ petitions is to an assessment order made by the assessing officer under section 153 capital C of the Income Tax Act 1961. Stop. Although the impugned assessment orders are being assailed on several grounds, including the ground of lack of jurisdiction, the court is of the view that the petitioners have an efficacious alternative remedy by way of an appeal before the Commissioner of Income Tax Appeals, as provided by the Act, consequently leaving it open to the petitioners to avail such alternative remedy and to urge all the issues raised in the present petitions before such appellate authority in accordance with law. The writ petitions are disposed of. In that event, may give me some protection. There is a huge assessment, the demand raised against me.
There is a provision, sir. Under the Income Tax Act, there is a provision.
Till filing of my appeal,
you know that, sir. You will always file an application for interim relief before the CITA.
See, problem, my lords, is that there is no provision where we can file an application for interim relief before the CIT appeals. I mean, my lords, it is the NFAC now, the National Faceless Appeal Center.
There is, just read the act carefully. We're not giving free legal advice here.
Okay.
You are far more learned and enlightened than we are. Yes.
No, that's
Right. Supplementary list for
So great.
orders. For orders, item number 8.
My lords, all the 3 cases.
Yes.
Very good.
789
Right.
My lord, this writ application has been disposed of.
Right.
3 formal miscases were pending then at the time of disposal. May I pray this is for addition of parties?
No, all this is not relevant, sir. No.
My lord, because
These applications do not serve, do not
no,
survive.
2 persons have expired. So that's why during argument I gave 2 miscases and also 1 miscase was pending since 19. May I pray your lordship may kindly say that 5471 of 19 petition number 9 has expired. Why wants to be
All right. In all these 3 applications, you say for reasons stated, all 3 applications are allowed.
my lord? All right. I would file or corrected cost title
Corrected cost title will be filed within a week. All right.
within one. Yes, my lord.
Supplementary list for orders, item number 9.
Item 9, my lord. On behalf of Mr. Senior Counsel Ashok Mahanti, I pray for after vacation, your lords.
Sorry, pray for what?
After vacation, your lords.
Why did you get it listed then?
One IA has become infructuous virtually. IA number 481 by 2022.
That
that has
I
become
became
infructuous.
infructuous, my lord, in the meantime.
All right. IA 481 of 2022. Counsel for the applicant informs the court that this application has become infructuous. It is disposed of as such.
Paper book has not been made ready, Lordship.
Sorry?
For preparation of the paper book, Lordship passed the necessary direction.
Lord, one IA is there, my lord.
Paper
for
book is
bail.
not ready.
Not ready.
The paper books be prepared. Where is it say it's not ready? Anyway, paper books be prepared and supplied to counsel of the parties for the next date. At least 1 week prior to the next date.
Supplement-
5th August.
Supplementary list, item number 10.
May I plead, my lord, in this case, petitioner files this case, my lord, for appointment of peon, my lord, under rehabilitation assistance scheme, and I have challenged also the virus of the notifications, my lord. In this case, already notice issued, my lord, but now I want to, in the meantime, I want to, my lord, implement the GA department as a party, my lord. So let it be
When are the other matters coming up?
7th July, my lord.
List on 7th.
And consolidated cost title, I may permitted to file.
First you amend, sir, then we'll see. Right.
Yes. Well, that amendment petition I will file, my lord.
So we
That,
don't know, sir. It is whenever it is numbered, it will come up.
Yes, yes, my lord, that number is there, my lord. 3741, my lord, your lordship will see of 2022.
All right.
I know.
374122. For the reason stated, the application is allowed. The amended writ petition have you already filed?
Yes, ma'am. No, my lord.
The consolidated petition.
I have to file the consolidated cost rate.
Yeah, and cost rate will be filed within a week.
Yes. Let it be posted on 7th July.
List on 7th July.
Yes.
All right. Main matter list on 7th July.
Supplementary list, item number 11.
My lord, here I filed the public interest litigation. My lord, your lordship will see the previous order passed by this honorable court at page number 31, annexure 2, wherein the guideline which has been formed by the government that whenever there is a tender, it should be, your lordship will see the guidelines I have given.
How is it a PIL, sir?
My lord, here 322 numbers of tenders were floated within 15 days. No completion certificate, no logbook maintained, no photographs taken, nothing is there, my lord. This is a huge scam of tender,
So
my
you
lord.
go to the Lokayukt, sir. Permitting the petitioner to move the Lokayukt in accordance with law, the petition is disposed of.
All right.
Supplementary list, item number 12.
Item 12, my lord, kindly time to remove the defects, my lord.
All right. Defects will be removed within a week. List thereafter.
Supplementary list, item number 13.
May I please?
1 minute. In item 12, 1 minute. Item 12, what is this matter about? Why is this private party here?
On behalf of Amita Bakchi, my lord, I have
My
instructed.
lord, it is against, I think, a order of an RERA order. The
How is a
impugn-
writ petition patentable? I don't know.
That is appellate forum is there.
Yeah.
This is passed by ORERA and that is appellable before the appellate authority. Annexure 2 is the impugned order.
So that is an appealable order. There's an appeal. It's an appealable
Yes,
order.
yes, there is an appeal. That is in Fortune
You
Tower.
say the
that appellate police.
order challenged is dated for order of the Orissa Real Estate Regulatory Authority dated 1st October 2021 has been challenged in this petition. There is an efficacious remedy for an appeal against such order provided under the concerned statute, permitting the petitioners to avail of such remedy in accordance with law. The petition is disposed of.
My lord, kindly allow me time because I have instruction to take time to remove the defects.
No,
my
that's
lord.
okay.
I
You
will-
may have instructions, but you have to be ready to answer the question. Right.
Item 13.
13, my lord, these two matters for 13 and 14 are directly covered by your lordship's judgment, my lord. Here your lordship appreciate that the very facts, my lord, that has been, my lords, based on complete change of opinion, my lords. Your lordship would kindly turn to page 73, my lords. That's part of my audit report, my lords. For a moment, for a primary satisfaction that this is complete change of opinion, my lords. Page 73, my lords.
Yes.
Under the head other expenses, your
Yes.
lordship would get it that works payment. That's the fourth column, my lords.
Yes.
That is 61145,504.25, my lords.
Correct.
Then the lordship may turn to page 93, which are the reasons for reopening, my lords. Here, my lords, 143.3 assessments were done, my lords. After 4 years, this is done, my lords. Page 93, your lordship got it, my lords?
Yes.
Paragraph 2. On verification of the audit report for the assessment year 15-16, informed number so-and-so, column number so-and-so, it is observed that the SSC department did not maintain cash books, but only maintained journal ledger and bank books. Further, on verification of record, it is noticed that during the year under consideration, the SSC has made a huge expenditure to the tune of 611.45.
So no new material.
No new material, my lords.
All right.
And your lordships has specifically held in this honorable court as well as Delhi High Court following Kelvinator, my lords. Lord, this change of opinion, my lord, is not permissible under law, my lords.
All right.
Your lordship would appreciate that 4 years after my 143.3 order, my lord, this 148 notice is being done and this assessment is trying to be made and has been made, my lord, completely on change of opinion.
All right. The challenge in the present petitions is to the orders dated 31st March 2021, issued by the
The assessment order is
Assessing officer,
28.3.
bracket AU, under section 148 of the Income Tax Act, 1961 bracket Act, seeking to reopen the assessment under section 147 of the Act for the assessment years.
No, 15-16 minutes.
There are two petitions here
The 215. This is for 15-16. The next one is 14-15.
for 1516 bracket writ petition civil 11277 of 2022 and AY 1415 bracket writ petition civil 11291 of 2022. Let's stop. The reason for reopening as provided to the petitioner. Which page is that? Reasons for
93 minutes.
93. Refers inter alia. 93 in the first petition, I think.
Minutes.
The second one, I wonder which page that is.
Second one, my lord, is
Refers to the audited report
second one is 86. Page
and the
86.
petitioner's claim for single quotes works payment, unquote. which was already disclosed in the original assessment proceedings. First off, it must be mentioned that the returns filed by the petitioner were in fact picked up for scrutiny, and assessment orders were passed under section 143(3) of the Act. Paragraph. The law in regard to reopening of assessments under section 147 has been settled in a large number of cases, including CIT versus Kelvinator of India Limited, 320 ITR 561 (SC), which has been applied by this court in its decisions in its decision Sri Jagannath Promoters and Builders versus Deputy Commissioner of Income Tax 2021 133 taxman.com 270 (Orissa). Counsel for the department is unable to dispute the fact that the reopening was not based on any new material, but only on a revisiting of the material that already stood disclosed at the time of the original assessment proceedings. Paragraph. This appears to be a textbook example of reopening based on mere single quotes change of opinion, unquote, which was disapproved by the Supreme Court in CIT versus Kelvinator of India Limited, Supra. On that short ground, the impugned notice dated 31st March 2021 under section 148 of the Act.
And the order of reassessment annexure 7 and demand annexure 8.
And all the consequential orders, including the reassessment order dated 28th March 2022.
And the demand notice.
As well as the consequential demand notices dated 28th of the same date are hereby quashed.
The second case, my lord, it's only reassessment order is 30th of March 2022.
Yes.
And demand notice is 30th of March 2022, annexure 7 and 8.
All right.
And the additional point I had, my lord, I need not bother your lordships. In 1516, my lord, it's the beyond 4 years joint commissioner.
Oh, okay. All right.
So that is for 1516 only, my lord.
All right. Anyway, that will be not. All right.
Greatly obliged.
All right.
That covers 13 and 14.
That's right. Put them together, 13, 14.
Supplementary list item number 15.
Supplementary item number 15, kindly add them the other date, because my seniors wife death anniversary today, we are going to Puri for Orissa.
What's the matter about? Let's see. You can't have a matter in the High Court and go off elsewhere.
Copy that.
Petitioner's representation dated 6th April 2022 be considered by the Secretary Department for the Government of Orissa. And after giving the petitioner hearing, reasoned order shall be passed thereon not later than
May I please your lordship?
1st August 2022.
May I please your
And be
lordship?
communicated to the petitioner not later than 8th August 2022.
My lordship, I am appearing for the opposite party, 326. My lordship, they have already filed a date petition before your single judge, and already they have taken a stay. And again, they are coming with a PIL, my lordship. And my lordship, they have already filed on 2012 with the same self ground, and that was dismissed by the single judge, my lordship.
Anyway, this Rengali hydroelectric
Yes,
project
my
is
lordship. Yes, my lordship.
no, it's a state public sector undertaking. Right?
Yes, my lordship, it is under OHPC, Odisha Hydropower Corporation Limited, my
Right.
lordship. The fact, if my
As
lordship,
well as you say petitioners, as well as opposite parties, opposite party number 3, Orissa
26, my
Hydropower
lordship.
Corporation. Only a representation we've asked to be disposed of on it.
Lordship, direct the representation to be disposed of by opposite party number 4 or 3, because secretary, the OHPC is to take a call.
yes,
He'll be hearing them also. Because the
not the
representation is addressed to the secretary.
Maybe, but why I am saying, because it will be difficult for them to, because secretary is otherwise in, but this matter relates to OHPC.
I know. So he'll hear the OHPC. He's going to be hearing the OHPC also. The court clarifies it is not expressed any view in the matter. All right.
Supplementary list item 16.
My lord, the situation in Cuttack city, so far as noise pollution is concerned, It is intolerable.
So
And
you have to go to
honorable-
the NGT, sir,
Don't, my lord.
for the complaint regarding noise pollution in Cuttack City. Remedies available before the regional bench of the National Green Tribunal in Calcutta, permitting the petitioner to avail such remedy. The petition is disposed of.
Supplementary item 17.
May I please, Your Lordship?
Yes.
Lordship, this is a public interest litigation, man. And the petitioners are the inhabitants of the district of Jagatsinghpur as well as Cuttack district, man. The issue is that, my lord, there is a river, namely Debi River, flowing at Ali Pengal Gram Panchayat, my lord, separating both the districts. And before 10 to 12 years, my lord, there is a state government has constructed a bridge over the Devi River so that the minimizing the distance of 70 kilometer to 7 kilometer, my lord. Recently, my lord, the collector Jagatsinghpur has directed to construct a barricade on the said bridge, and for which the school vehicles, ambulance, and heavy vehicles and vehicles carrying goods also are having inconvenience.
You made a representation.
Yes, a
Yes, I
representation
have
is at
filed-
page 27,
All right. The petitioner's representation,
annexure 2.
bracket annexure 2, shall be examined by the
Collector, District Magistrate Jagatsinghpur.
collector and district magistrate Jagatsinghpur. And after giving the petitioners a hearing, a reasoned order shall be passed thereon not later than 1st August 2022 and be made available to the petitioners not later than 8th August 2022. The court clarifies it has not expressed any view in the matter. All right.
Deeply interested.
Supplementary list item 18.
May I please, Your Lordship? In this case, the opposite party number 7 to 12 are constructing a Ma Bhagavati temple over the public road, my lord.
Your representation is there.
My
The
representation
petitioner's
is
representation dated 25th March 2022. But have you made them? Okay. Where is the proof of this representation having been sent? Where is the proof, sir, of receipt by the Tahsildar?
Well,
My lord,
by
apart,
hand, by
apart from that, he has already taken resort to 144.
yes, my lord. In spite of several directions, the
No,
Tahsildar,
no. Where is the proof of delivery
There
of
is-
this representation to the
there is no-
Tahsildar?
There is no.
by hand.
No, no. Where's the receipt? You must have a receipt at least. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the authorities concerned and following up on such representation to seek appropriate remedies in the course of law. The petition is disposed of the above terms. As withdrawn with the liberty is paid for.
Earlier 2 occasions, my lord, kindly say annexure
So we need
Three,
proof
my
of, proof of the representation having been delivered.
my lord.
I would have-
Earlier 2
Item
occasions, my
19.
lord, the ADM Baleswar directed to Tahsildar Remuna to restrain the opposite party number, such and such.
So your representation, you have to deliver it to the Tahsildar. All right. Yes.
Supplementary item 19.
Item 19. In super cyclone, yes, many projects have been affected in Balasore district, my lord. The opposite parties, without approving
Anyway,
the
representation again.
annexure 4, my lord.
All right. The petitioner's representation, bracket annexure 4, shall be examined by the Special Relief Commissioner.
No, BDO
BDO
Khoira block.
Khaira, my lord.
BDO Khoira.
My lord,
By the
directed
BDO
to
Khaira.
Collector Baleswar, my lord.
No, you have addressed it to BDO
My
Khoira.
lord, in the copy to Collector Baleswar, copy to Secretary.
All right. To collect by the collector
Okay.
Baleshwar, bracket opposite party number 4. And after giving the petitioners a hearing, a reasoned order shall be passed not later than 1st August and be communicated to the petitioners not later than 8th August. The court clarifies it is not expressed in the matter.
Deeply pleased.
Supplementary list item 20.
Your Lordship, item number 20, kindly permit me to appear through VC, Your Lordship.
Yes, yes.
Your Lordship, this is an application in nature of public interest litigation, but admittedly, we have not filed a representation. Therefore, the defect, Your Lordship.
Then you withdraw and go for a representation, sir. Counsel, the
Your Lordship.
petitioner seeks leave to withdraw this petition with liberty to file a representation to the authorities. After following up on such representations to seek appropriate remedies in accordance with law.
Obliged, Your Lordship.
All right. Disposal is withdrawn with liberty.
Supplementary list item 21.
May it please the Lordships. Lordship may kindly see annexure 2 at page 18. The petitioner's husband died. And on October 19 ballots. Thereafter ballots, Lordship may kindly see, she was not substituted. And 6/11/2019, an order of assessment was passed against her husband on 6/11/2019.
What is the date of death?
Ballots?
What is the date of death of the husband?
Date of husband is Annex 2. Date of husband is ballots.
The assessment order was passed after his death.
Yes. Yes.
So that is
What I say now, just a minute, Mr. Mapati, just a minute. Now what they have done, they have proceeded, resorted to section 226, bracketed 3, that garnishee proceeding ballots. By attaching, her husband got some amount from the MCL for the land acquisition. He kept the amount in the shape of FD. Now, whatever the amount was getting, she was getting as interest, now that has been attached. I'm giving. Sorry, my lord, it is in.
So how can assessment order be passed against a dead person?
Prior to that, my lord, notice was issued prior to 1 year of.
No, but when you pass the assessment order, the man has died.
That was not brought to the notice of the, my lord, assessing officer, my lord. Lordship, during the proceeding, the deceased was issued notice, my lord. He was sought with the notice.
No.
So kindly have a glance to page 8.
No, but by the time he passed the assessment order, he died, sir.
What I pray, my lords, let it go back to the assessing officer. Let them substitute and continue the assessment.
The late husband of petition number 1 was assessed to income tax by an assessment order dated 6th November 2019, passed by the Income Tax Officer, Ward 1, Jharsuguda, bracket ITO. Full stop. The truth of the matter is that, the fact of the matter is that even prior to the date of the assessment order, that is 6th November 2019, the husband of petition number 1 expired on 12th October 2019. As a result, the assessment order came to be issued in the name of a person who was not alive. Paragraph. Counsel to the department seeks to justify the order by pointing out that the department was unaware of the death of the husband of opposite parties of the petition number 1. Be that as it may, since no assessment order can be passed against a dead person, the court sets aside the impugned assessment order dated 6th November 2019 and remands the matter to the file of the ITO Ward 1.
Or one Jharsuguda.
Jharsuguda, for being passed once again afresh after hearing the legal representatives of the deceased SSC, who are the petitioners before the court. Full stop. For that purpose, the matter is directed to be placed before the AO on
July
20th June 2022, on which date the present petitioners will appear before the concerned AO on behalf of the deceased SSC. And after substituting them, the AO will further proceed in the matter in accordance with law. The petition is disposed of in the above terms.
Tomorrow is the last day for vacation matters.
Correct,
I wish matters get vacation ballots.
Yes. A badly needed break. And all of you too.
Thank you, ballots.
Thank you.
Problem is vacation, there is no fees.
But you have to also enjoy the fees that you have earned through the year.
Much obliged.
All right.
Supplementary list item 22.
Item 22, may I please, Your Lordship?
Yes.
My Lord, pursuant to Your Lordship's last order, we have filed the compliance affidavit, my Lord, but I think it may not have reached Your Lordship's file. I've handed over the hard copies, my Lord. Your Lordship wanted us to answer on his query regarding Kalahandi thing, my Lord, Kalahandi report. We have specifically stated in para 7 the steps that you have taken.
All right. No, in one Gram Panchayat, he said there are 100 villages.
And
Millards, in that Rasulpur block, with regard to Rasulpur, Millards, this is with regard to Kalahandi, where Millards, survey had been conducted, and I have given the survey report in my additional affidavit dated 6th of January. In that, Millards, as per the survey, about 187 odd persons who are named, Millards, in the survey, they have been left out. Either, Millards, they don't have Aadhaar, or, Millards, their Aadhaar is not linked. And that, Millards, will find if Millards takes my additional affidavit dated 6th of January 2022 at page 20, Millards.
Para 8 also we have answered. Para that we are adhering to the bypass, Aadhaar bypass procedure.
No, what about these 187? Are they covered?
Millards, there, as per their counter affidavit, Millards, they say in para 7, as regards non-addition of new members in the existing ration cards, steps have already been taken to verify these cases and included in the ration cards. But Millards, there is no report saying that they have actually been included, because if they included,
the process is going on, my lord, because every application that we receive is being inquired, and then
you have the names of those 187 persons.
Yes, Millards, I have given it in the report, and the report had been shared with them, and the report has the names.
So why did you confirm these names?
And today also, I'm really thankful to my brother that he has given us a report where he has named some beneficiaries. He's filing this as extra.
May I just place that?
Where he has named some beneficiary of different districts. And so we will make an effort to find out these people and do the needful matter. These are
This again, Millards, and this is important because this is, Millards, pursuant to my lord's order, where in the last occasion they said that they have issued fresh notifications with regard to no beneficiary being left out due to non-linking of Aadhaar or not having Aadhaar. Thereafter, Millards,
I do appreciate my brother's
Millards, what is happening is, Millards, the state, Millards, I have to, Millards, bring it to your notice. In every affidavit, Millards, the state is making this blanket statement that no one is being deprived.
This is all over. You see, a compliance affidavit has been filed by the Additional Secretary to the Government, Food Supplies and Consumer Welfare Department on 18 May 2022, pursuant to the order dated 28 March 2022 of this court. It is sought to be contended that the state government is ensuring food security for 95,74,675 families, comprising 333,27,255 members, which is 79.4% of the state's population. It is further claimed that coverage under the NFSA is 99.6%, with reference to the Government of India upper ceiling. It is also claimed that ample target is available under the State Food Security Scheme (SFSS) for inclusion of new beneficiaries seeking food security, if eligible as per the single quotes inclusion and exclusion criteria notified by the state government. Paragraph. Counsel for the petitioner, on the other hand, is placed on record today with a memo. Copy of a report on exclusion from TPDS due to Aadhaar. This is a report by the Orissa Khadia Adhikar Abhijan. So the report itself is based on the field survey undertaken by the said organization between 10th and 15th May 2022. Paragraph. Enclosed with the report is a list of 102 persons living in the districts of
There are 7 districts, my lords, which my lords will find at page 3.
districts Bargad,
Kalahandi, Kandhamal,
Kalahandi,
Malkangiri.
Kandhamal, Koraput, Malkangiri, Sundarnagar, Sundargarh, and Malkangiri.
And Sambalpur.
Ms. Shashrita Patnaik, Learned Government Council, undertakes to hand over the said survey report to the concerned department and file an affidavit before the next date confirming if these left out persons have since been restored their ration cards. List on.
My lord, regarding the PowerPoint presentation, my lord, though we were ready today, my lord, but I'll seek one adjournment, my lord, because we want to give the entire statistics district wise,
Right.
how much we have covered, my lord.
So we'll have it in the
Plus with some visuals, my lord.
second week, 27th June.
27 June. Oh, bless.
Grateful.
Oh, bless, my lord.
Is it possible, my lord, the copy of this same is, sir, then you can apprise the government of India in this regard? Some cases, government is a party.
I see. Okay, copy of the affidavit and survey report be furnished to Mr. P.K. Padi, appearing for the government of India.
Oh, bless.
Supplementary list item number 23. In this case, my lord, petitioner have challenged the my lord, virus of notifications of under notification 2016 and 2020, my lord, in order to get appointment under rehabilitation scheme rules to 1990, my lord. Similar such type of matters, my lord, posted to 7th July 2022. You will also may issue notice to the opposite parties after admitting. And along with, my lord, 14,000.
Notice has not gone in these petitions.
Pardon?
Notice has not gone.
Fresh admission, that is fresh admission.
No.
Your lordship may admit and issue notice to the opposite parties by posting it to 7th July 2022 along with the WPC number 14,078 for 2020. My lord. Similar such type of matter was posted to such that.
Notice who's for the state?
I am for the state. My lord, school and mass education, I am
for the opposite parties. Reply within 4 weeks. Adjourned up for the next date. List on
7th July 2022.
All right.
Along with the 14,078 of 2020.
2020. 14,078 of 2020. All right.
All sub items are
same order.
Oh,
Supplementary list item number 24.
24 minutes. I am on virtual mode minutes. This is a criminal appeal minutes. I have submitted today a note. Can I pray? Maybe taken up on reopening date.
No, sir. It's a 2000 matter.
Minutes. The appellant number 3 has already, whose bail was rejected. He has undergone sentence and has been released. Appellant 2 and 3, they are supposed to be. I'm only praying on reopening. Physically, I am not fit because I had a fall. I prepared a written note yesterday night.
All right. Written note of submissions has been submitted. Mr. Das, Senior Counsel, appearing for the appellant, states that he's in some personal difficulty today. List on 28th April, sir. Opening day?
No problem.
20th June, sorry. 20th June.
Electrical period, flag C. Flag C.
Right. 20th June.
Right. Plus flag C, you also can peruse. There is a letter from the.
Yeah, you say, also note that appellant number 3 has already served out his sentence and has been released from jail. Right.
Supplementary list item number 25.
May I please your lordship? I am in Vichy, my lord. My lord, in this case, matter was earlier listed for another bench, my lord, and we had already submitted the written note also, and we had our argument was over initially, my lord. But I pray for time, my lord. I will prepare again the brief and.
Sir, all these are 20-year-old matters. This is 21 years old.
My lord, yes, my lord. Our written note we had already submitted, my lord.
How many adjournments for matters like this?
My lord,
It's a 20-year-old
one
matter,
adjournment,
sir.
my lord, we had already. I am a junior counsel, my lord. We have already submitted the written note also, as
Then-
well as my lord. In our part, we had already argued also. From
All right.
our end, it was closed, my lord.
So we
But
should we
your
treat it as
lordship, my lord,
closed? Shall we treat it as closed? You want to treat it as
my lord,
closed?
I may be permitted to argue. No, my lord, we want to argue another time on your bench.
No. So today, why don't you
On your
argue
bench, we
today
want to
then?
argue, my lord.
Why don't you argue today?
Lordship's bench, we want to argue. My lord, I'll prepare again, my lord. Time because two accused are there, two appellants are there. It's a 302 case, my lord.
So
Being
when I
a junior
ask
counsel,
you,
I
when I ask you, do you want an adjournment? You give me a long explanation how you've already given a written note, how you've already argued the matter. When I ask you, do you want to treat it as closed? You say, now I want to again argue. When I ask you to argue, again ask for an adjournment.
Now I am not ready, honestly speaking, my lord. One seek, one adjournment, my lord.
So it's a 21-year-old matter.
I understand, my lord. My lord, seek one adjournment, my lord.
Why don't you argue, sir? Why don't you argue today?
Being a junior counsel, my lord, I seek one adjournment, my lord.
None of you is prepared, sir. None of you is prepared to argue any criminal appeal. Mr. Nayak, you are Mr. Nayak.
No, my lord, I am a junior, my lord, junior. Akash Bhuya, my lord.
What is your Akash Bhuya?
My lord.
Mr. Akash Bhuya, Learned Counsel, the appellants seeks one last opportunity to get ready with the arguments. List on 28th June. Opening day.
Sir, my lord, one day after, my lord. I pray for one day after, my lord.
All right, 21st June.
Supplementary list item 26.
Obliged.
Appearing on BC on behalf of Mr. Debashish Panda, Your Lordship. Am I audible, Your Lordship?
Now you are.
I'm appearing on behalf of Mr. Debashish Panda, Your Lordship. Am I audible, Your Lordship?
Yes, please.
Your Lordship, Mr. Panda is in personal difficulties, Your Lordship. Can the matter be taken up
Adjournment. Nobody wants to.
after vacation?
You say Mr. Devashish Panda is stated to be indisposed. List on 21st June. Right.
Supplementary list item 27. So noting is there the appellant has filed a memo, my lord. Appellant 4 and 5 have died. They have filed a memo.
All right. There's a memo stating appellants 4 and 5 have died. As far as they are concerned, the appeal appeals and it's dismissed. What about the other appellants?
One has abetted earlier, my lord. Lordship may see the cost
So
settlement.
2 and 3 are left.
My lord, 3 has abetted while order number 9 earlier. Now, out of 10 accused persons, my lord, 3 gone. So 7 remain.
Okay. There are still 7 appellants in the fray. Appellant number 3 has also died. So there are 7 appellants in the fray left. Who's for the appellants? None appears for the remaining appellants. Are they all on bail, sir? Or
My lord, as it appears from our record, my lord, yes, they are on bail.
the present status of the said appellants be placed before the court by the next date by the IIC of the concerned police station. Meanwhile, a complete set of the paper books be handed over to the Secretary, Orissa High Court Legal Services Committee, (OHCLSC), for being entrusted to a panel counsel of not less than 10 years experience to appear for the appellants. The set of papers will be immediately entrusted to the panel counsel, who will get in touch with the appellants for instructions. 23rd June.
Supplementary list item 28. Lord, I am entering my appearance through the appellants and prefer an adjournment so that I can avail the appeal memo and all the relevant records.
Flag F has come, my lord.
Kindly say.
It's regarding the
Order dated 5/5.
whereabouts of the appellant.
Yes.
How many appellants here?
My lord, here. My
Four
lord.
appellants and Gunapanta Biswal, the appellant number 1 has got expired. And other 3 appellants are present here. And I have been entrusted by them so that I am entering my appearance, Lord.
One has expired.
Gunapanta Biswal.
So why don't you get ready and argue the matter?
I have no appeal memo, Lord. I have no records, Lord. So I will avail it and Lord, may kindly fix another date.
What is your name, sir? Sangramjit Panda.
Yes, Lord.
Mr. Sangramjit Panda, advocate, enters appearance on behalf of appellants 2, 3, and 4. It may be noted that appellant number 1 has expired, and the appeal as far as he is concerned is abated. Mr. Panda states that he will collect the paper books from the registry and get ready with the matter. List on 20th, opening day, sir, 20th June. Right.
Supplementary list item 29.
29, I have not received the paper book, so I am not ready. I pray that this matter may come after vacation.
So we are going to announce a special reward for any advocate who is ready to argue. Today, not a single advocate is ready to argue any matter. It seems that you are coming here to the court only for asking adjournment.
Only pray after.
Sir?
I have not received the paper book.
Counsel to the, what's your name, sir?
PK Mahanti.
Mr. PK Mahanti, learned counsel for the appellant, states that he will collect the paper book from the registry and get ready with the arguments. On the next date, it is made clear there will be no further adjournments. Let's start. 23rd June. No, I think we give a break and come back. Otherwise,
In fact, in all these appeals, we are ready.
I know.
Item number 1 in the VP list, my lord, I am ready.
You're ready? Let us start. Let us start. That's the best news we've heard so far.
Weekly list old matter item number 1.
Yes.
And there are 2 appellants.
Yes.
Appellant number 1 was convicted under section 302 and imprisonment for life. Appellant number 2 was convicted under section 325 and 4 years.
Right.
They are the son and father. The appellants are the son and father.
Right, sir.
Appellant number 2 is dead. Plus appellant 2 is dead.
Dead, yeah.
And
So for appellant number 1 is concerned, my lord, there are 4 eyewitnesses to the occurrence.
Right.
That is PW 4, 10, 11 and 12. PW 10 is the son of the deceased, my lord.
Right.
He is also an eyewitness to the occurrence. Your lordship will kindly, I have taken 3 grounds, my lord. Your lordship kindly turn to page 44, PW 4, my lord.
Yes.
I know so and so. The occurrence took place at about 10 a.m. Myself, Lobo Kishan and Kendru Kishan, after plowing the land, united the untied the bullocks and went to the nearby Jora to take bath. After taking bath, while we are coming towards the village, we found the deceased Govinda Kishan along with his son Bina Kishan. We are coming towards the village ahead of us. At that time, we found accused Raghu Behra tending his bullock. At that time, deceased Govinda confronted the accused Raghu as to why the Raghu plowed the land of Govinda. Raghu replied that the land belonged to him, and for that he plowed the same. There was altercation between them regarding the ownership of the land. In course of altercation, accused Raghu stood up holding the axe and dealt a blow with the axe on his forehead with the blunt side of the axe. At that time, the handle of the axe was broken. The accused Raghu and deceased Govinda caught hold of each other and galloped each other. At that time, the accused Narayana jumped to the fence and ran towards the deceased and his father and snatched the axe from the deceased Govinda and dealt blow with the axe on his right arm and another blow on the chest. We were restraining him not to assault, but he did not pay any heed to it. He assaulted with the sharp side of the axe. There was profuse bleeding from the wounds. Thereafter, both the accused left the place together and Narayan taking away the axe with him, with which he dealt the blow. The broken axe was lying there. Out of one's curiosity, we stood there near the deceased. After some time, in our presence, the deceased read his last there. Bina was also standing with us. We advised him to report the matter to Gramaraki. We saw the occurrence by standing at a distance of 20 feet from the deceased. This is the evidence of PW4, my lord. The deceased is the aggressor. He has, my lord, made an altercation with the father of the appellant number 1. Thereafter, the incident took place.
Correct.
And so far as appellant number 1, the son is concerned, he was not coming to the spot holding any of the weapon, my lord. He snatched the weapon from the accused, from the deceased, and dealt blows, my lord. So far as the father of the appellant number 2, who has already expired, my lord, he has also, my lord, sustained some injuries. PW1 is the doctor who has
How many
examined
injuries on the deceased?
Pardon, my lord?
How many injuries on the deceased?
This is, my lord, only PW2, my lord.
Page 38, please. Page 38.
Let's see that.
And PW1, my lord, you also will kindly see, he has examined one of the accused, he has sustained injury. And you will also will kindly see the evidence of the informant, PW10, my lord, who is the son of the deceased, my lord, at page 58, ma'am. Well, I'm permitted to place. So while, I will start while returning to my house.
Yes.
I was on the way. I heard my father asking accused Raghu Buddha as to why they ploughed our land. I found my father and accused Raghu Buddha dealing blows with blunt side of the axe to each other. At that time, accused Narayan Behera came running and snatched away the axe from my father. Accused Raghu provoked him to kill my father. Accordingly, accused Narayan dealt blows with sharp side of the axe on the right side hand and the chest of my father. Thereafter, you will also kindly see the next page, my lord, the cross-examination. The sentence starts, my lord. We do not have land record in respect of the land which was plowed by the accused persons. My lord, my contention before your lordship, my lord, the deceased is the aggressor. He has, my lord, quarreled with one of the accused, the father of the appellant number 1, my lord. Thereafter, the incident took place, my lord. And there was a free fight. Both of them were holding, as per the prosecution's case, my lord, I am not going to any other. Both are holding the deadly weapon, my lord, that is, my lord.
No, both are farmers,
Axe.
so they will have access. There's no question of that.
And both were holding axes.
Correct.
And
the son was not holding any axe. He snatched the axe from the deceased and hit the deceased.
Again. And the injury which was sustained by the father of the, my lord, appellant number 1 is on his head, my lord. my lord, submit, my lord, that in order to, my lord, for private defense, the son has assaulted the deceased man.
Yes, what do you
Right of
say?
private defense is available, sir.
Because
His father is being assaulted.
No. Let's see how the incident is happening.
Yes.
Raghu is confronting the deceased, saying, "Why are you plowing my land?" So the deceased provoked Raghu by first attacking Raghu.
Okay.
Raghu is the father.
Yes.
Narayan is the son.
Yes.
Narayan then rushes. Narayan is not armed. He rushes there. And Raghu tells Narayan, "No, you better kill him."
Yes.
That's what this PW10 says.
Yes,
Then Narayan picks up the axe from the deceased and deals 2 blows, I think. One on the arm, one on the chest.
Yes.
Because the third blow is already given by the father.
Yes.
So Narayan gives 2 blows.
Yes.
One on the chest and one on the arm. So this is sudden provocation. There's no question. So we can apply 304. Part 1. Part 1, I think. Part 1. How many years has he spent?
My lord, nearly 7 years, my lord, because I have taken note of the fact that immediately after the occurrence took place on 8/7/98, and they were released on bail on 23 to 10/1/2005.
7 years.
And so far as 304 part 2 is concerned, my lord, the honorable apex what I have brought, my lord, 2 years imprisonment has been awarded.
I know, but anyway.
And in the instruction I have
This will be
received,
part 1, madam.
In the instruction I have received on 21st March 2021, the surviving appellant, Narayan Behra, was by that time he was bedridden, being affected with paralysis since last 3 years.
Oh.
So last
Or that could be another reason. You say there are 2 appellants before the court, agreed by the judgment dated 12th February 2003, passed by the learned Sessions Judge Devgad in ST case number 40/13 of 1999-2000, convicting appellant number 2 Raghunath Behra under section 325 IPC and sentencing him to undergo rigorous imprisonment (RI) for 4 years. Convicting appellant number 1 Narayan Behra for the offence punishable under section 302 IPC for committing the murder of Govind Kishan and sentencing Narayan Behra to imprisonment for life At the outset, it requires to be noticed that during the pendency of the present appeal, Narayan Behra was enlarged on bail by an order dated
10/1/2005.
10/1/2005. The second fact to be noted is that appellant number 2, Raghu Behra, has expired, and a report to this effect has been received from the IIC Devgad PS on 21st March 2021. Paragraph. The same report also refers to the fact that appellant number 1 Narayan Behra is bedridden, being affected with paralysis since the last 3 years. Paragraph. The background facts are that both the accused and the deceased were co-villagers of village Saloi under the Devgad PS. A piece of land possessed and cultivated by the deceased was plowed by the accused Raghunath Behra. Full stop. Paragraph. On 8 July 1998, around 10 a.m., the deceased Govind Kishan was returning from his paddy field, followed by his son Bina Kishan, bracket the informant, bracket PW10, bracket. Full stop. They found the accused Raghunath Behra on the way. Accused by Raghunath Behra, bracket, appellant number 2, bracket, on the way, and asked him why he had plowed the land belonging to Govinda Kishan.
Hey, reverse, my lord. Govinda asked the Raghunath Behra why he is plowing his land, my lord.
Yeah, Govinda only asked.
Deceased asked.
That's right. And deceased asked. Sorry. They found, the deceased found accused Raghunath Behra and asked him as to why he had plowed the land of the deceased. Correct. Full stop. There was an altercation between Govinda Kishan and Raghunath Behra over this. Full stop. They caught hold of each other. Full stop. While Govinda Kishan gave accused Raghunath a blow on the blunt side of the axe. Accused Raghunath also dealt a blow with the blunt side of the axe on the forehead of the deceased. Full stop. The handle of the axe was broken and the tussle went on. Paragraph. In the meanwhile, appellant number 1 Narayan, bracket A2, jumped across a fence and came running and smashed the axe from the hands of the deceased, Govinda Kishan, and gave him blows with the sharp side of the axe on the right arm and chest. Full stop. A witness Buntlu Kishan, bracket PW4, and Govinda Kishan's son, Bina Kishan, bracket PW10, tried to intervene to stop the assault. Full stop. Both the accused are stated to have then run away. Paragraph. There are 2 eyewitnesses.
4 eyewitnesses. PW 4, 10, 11, and 12.
4,
10,
11, and 12.
11, and 12.
Right. There are 4 eyewitnesses examined by the prosecution. Full stop. These were PWs 4, 10, 11, and 12. Full stop. The trial court, on examining their evidence, found it to be reliable and consistent and proceeded to convict the accused persons on that basis for the offences already mentioned and sentenced them in the manner indicated here and before. This court has heard the submissions of Ms. Dipali Mahar Patra, learned counsel for the appellant, and Mr. Katke, learned additional government advocate for the state. Paragraph. Both from the evidence of PW4 as well as PW10, the sequence of the events clearly emerges. Stop. It indicates that the deceased confronted the accused over the plowing of his land, which the accused number 2 was claiming to be his own. Stop. In that altercation, both accused appellant number 2, Raghunath Behra, and the deceased Govinda Kishan dealt blows to each other, but with the blunt side of the axe. Full stop. As far as appellant number 1, Narayan Behra, is concerned, he did not come there armed. He crossed the fence and tried to intervene since his father was being attacked. His father, Raghunath Behra, bracket, appellant number 2, bracket, was being attacked. He then snatched the axe from the hands of the deceased, Govinda Kisan, and on the urging of appellant number 2, attacked Govinda Kisan on the arm and the chest. Clearly, this was in the heat of the moment and on grave and sudden provocation in the form of the father of the accused being attacked by the deceased. Full stop. Paragraph. The ocular evidence that has emerged from the mouths of both PWs 4 and 10 finds full corroboration in the medical evidence. Full stop. PW 2, who conducted the postmortem, has stated that he found following wounds on the body of the deceased. Take from page 38 of the paperwork. Two of the above injuries are stated to have been caused by the accused Narayan Behera, bracket appellant number 1 here. Stop. However, the fact remains that he had come to the scene unarmed, and it is on account of his father being attacked by the deceased that he was provoked to reacting to it and gave a fatal blow on the chest of the deceased, to which he succumbed. Stop. This was not certainly a pre-planned murder, and therefore the ingredients of explanation 4 to section 300 of it being culpable homicide not amounting to murder would stand satisfied. Stop. The court is of the considered view that the offense is punishable under section 304 part 1 part 2 or part 2 IPC, since it is essentially an offense as a result of grave and sudden provocation and over a piece of land. Full stop. The appellant number 1 already having undergone nearly 7 years of imprisonment. The sentence is confined to the period already undergone. The appeal is accordingly dismissed, disposed of. The bail bonds of appellant number 1 stand discharged.
Weekly list item number 2.
I think we'll come back. Take it up at what, 12:30? 12:30. Come back. I know. Are you waiting for some matter?
No, I am here only to ask this court to some matters. Will go on. I'll ask you.
All right. Maybe call out. Let's see what it is.
Weekly list old matter item number 2.
What about the whereabouts? Yeah. What's the report on whereabouts? The mic.
We have communicated the order mallet of 2021. And also I have talked with the IC on it in course of day. She will intimate me regarding whereabouts of the appellants.
So let it
In
remain
fact,
on
this
both.
case of 98 are then custody. And our order sheet was that they are not granted bail, subject to verification of lordship's order sheet. So if that is so, then they must have been in custody for more than 20 years.
That's what.
So
we should know where are they, no?
So whether
I mean, sometimes they serve out the entire sentence and they're released.
Yes, prematurely they must have been released.
So we need to know. In fact, the other day, if you remember, there's one matter we had reserved judgment. The report that you had given us that IIC finds the prisoner to be in the village with his family, but there was no bail order.
That case, probably I was conducting my lord. Today in the morning, I've informed the IIC to find about the whereabouts and also to ascertain as to by which order he has been released on bail.
Or was he on parole or something?
Or in any case, so that my lord, he's ascertaining by today evening, my lord.
Yeah, you have to give it to
I'll
us.
try that.
So in 2, we'll just await.
My lord.
What about 3?
Item 3 plus is available. 3 plus it is. I have received the report on 7th April 2021. Staying at his village Gaganpur with his family members and doing labor work for running of his family.
All right. He's on bail otherwise. No, he has been released on bail, no?
Yes.
You say the report dated 7th March, 7th April 2000. 7th April.
Bail has been granted on 16th March 2004.
Right. So this is 7th April, this report. No, the report that you read out from is 7th April.
It's 7th April.
Of IIC?
IIC was Kabi Nagar.
Kabi Nagar. Gajapati district. Ganjam district. All right. The report dated 7th April 2022 of the IIC Kabi Nagar, Ganjam district, is that the appellant is residing with his family members in his village. None appears to the appellant. Notice without process fee be issued through the IIC to the appellant to remain present in the court on the next date. A complete set of the paper book be provided to the Secretary, Orissa High Court Legal Services Committee, OHCLSC, for him in turn to entrust them forthwith to a panel counsel of not less than 10 years experience, who in turn will get who will get in touch with the appellant for instructions. List on 14th July.
List item number 4.
Item 4. There is a report of the Superintendent Subjal Career that is at flag B. Lords, kindly because I have not. I don't have the copy. Item 3.
He has been prematurely released from jail custody. He has been released from jail custody.
Yes. Thank you.
The report of the Superintendent Subjail Career dated there's no date, nothing. Yeah, dated 21st February 2022 is that the appellant has been released prematurely from the jail custody on 20th February 2022. In that view of the matter, the appeal is disposed of.
Milord, I am appearing.
All right. He just put down his appeals. Right.
Item 3, Milord.
Item 3, Milord.
3, you are appearing. Please argue.
Yes. Milord, the appellant is 69 years old. He has been convicted under section 302 and 34 IPC. Your Lordship may kindly see. Charge was framed against 3 accused persons. Out of 3 accused persons, 2 accused persons are acquitted, and the conviction laid against this appellant. Your Lordship may kindly see the defective investigation. The whole investigation is defective. Your Lordship may see the admitted and the relevant fact of the IO. There are 2 IO, P88 and P99. Your Lordship may kindly see. And the MO1 is Tangi. That has not been seized. That is admitted by the IO. Your Lordship may kindly see.
Let us read that para 2, sir. Let's get the facts first.
Para 2 of the
judgment.
Judgment, Your Lordship. Para 2. The prosecution case is there. This is Tuna Behera was staying since last 2 years prior to his death in the house of his brother-in-law Prafulla Behera PW1 and his sister Jhuna Behera PW2 in village Ganganagar,
Ganganapur, sir.
And was running a grocery shop there in the said village. The villagers were annoyed with Tuna for creating disturbance in village life. On 1/7/2001, 30 to 40 villagers chased Tuna to drive him out, and Tuna fled away from the village. In order to solve this misunderstanding between the villagers and Tuna, Prafulla, the PW1, convened a village meeting, and in the said village meeting, it was decided that the meeting can only be concluded only in the presence of Tuna. And as such, on 2/7/2001 evening, Tuna came back to his brother-in-law house. The decision of the village meeting was convened to him by Prafulla PW1. On that day, at about 8 p.m., PW1 Prafulla and PW2 Jhuna, the sister of the PW sister of the deceased, my lord. On that day, at about 8 p.m., PW1 Prafulla and PW2 Jhunu left their home for seeing the car festival in the village, and deceased Tuna slept in the backside veranda of their house after taking food. Thereafter, at 11 p.m., when Prafulla and Jhunu returned to their house, they heard Tuna shouting Marigali Marigali from backside of the house, and hearing the same, when they proceeded to the backside, they found 7 to 8 culprits assaulting by means of tangi and katti, and they seeing them, PW1 and 2 fled away, and in the moonlight housed Narayana Patra, accused Narayana Patra, the present appellant, your lordship, was identified there by Prafulla Behera PW1. Thereafter, Prafulla and Jhunu administered water to Tuna. Tuna succumbed to injury. PW1 and 2 shifted Tuna to their front side veranda, reported the matter to the Gramarakhi Nandi Nayak, PW3, and as Samiti members and the Sarpanch of the village. Then the Gramarakhi came, and on the next day morning, Gramarakhi PW3 telephoned to the Kabisurjanagar police station. On the basis of the aforesaid telephone, called the OIC of case Kabisurjanagar police station, that is PW9, made a station diary by entry number 53/7/2001 of Kabisurjanagar PS marked Exhibit 3, and proceeded to occurrence village along with the SI RN Das, PW8, and other police personnel. And on arriving in the village, the OIC received a written report scribed by one Sarat Chandra Mishra, PW4, from Prafulla Behera, PW1. On receipt of the said report, he made necessary endorsement for treating the same as a FIR Exhibit 1, and directed SI of police RN Das, PW8, to proceed with the investigation. Thereafter, the OIC returned to PS, registered the case number 56.
So this is eyewitness.
Yes, my lord.
So PW1 is the eyewitness.
Yes, my lord. That your lordship may kindly see. The eyewitness PW1. I am the informant. Deceased Tuna Behera was my brother-in-law. Tuna is a permanent resident of village Ramchandrapur. 2 years prior to his death, Tuna was staying in my house at village Ganganapur and was running a grocery shop. Tuna died on 2/7/2001 at about 11 p.m. Prior to his incident, there was misunderstanding between my brother-in-law and villagers concerning collection of hafta from his grocery shop. On 1/7/2001, villagers had driven my brother-in-law from the village for which I had convened a meeting. The meeting was half concluded and committee members wanted my brothers-in-law to appear before them. On 2/7/2001, my brother-in-law returned home and I convened him. The decision of the Panchayat on 2/7/2001 at about 8 p.m. I and my wife proceeded to see car festival, and my brother-in-law Tunna slept on the backside veranda of our house at about 11 p.m. When I and my wife returned home, car festival had some disturbing sound from the backside of our house. Then I and my wife went to backside and found 7 to 8 persons assaulting Tuna. Seeing us, those persons fled away while Narayana Patra was still standing. My lord, the present person not assaulting nor holding any axe or any weapons, only standing. That the PW1 said that. And he was the last person to run away. We found Tuna lying severely injured, sustained bleeding injury on his hands, legs and head. We administered water to Tuna, who was in the last stage. Then I proceeded to the village and informed Sarpanch Gramaraki. Except Gramaraki, no other villagers came to the spot, and my villagers my brother-in-law succumbed to the injury within 10 to 15 minutes. On the very night, we wanted to contact police but could not succeed to no phone was available. On 3/7/2001 morning, I proceeded Kavi Surjanagar, on the next day, my lord, on the next day.
So what is wrong with this evidence?
Yes, my lord.
Let's read the cross-examination. You can read this cross-examination.
Yes, my lord. It is a fact that I have mentioned in my affair. With the help of moonlight, I could only recognize Narayana Patra out of 7 to 8 culprits. Accused Hinna Behera is my nephew, the one of the accused who was acquitted. Driver Behera, he is one of my brother. He was also involved in this case. He is acquitted. Since last 10 to 15 years, I am separated from my brother. House of Hinna Behera is situated at a distance of 200 to 300 yards from my son. On 2/7/2001 night, there was rain at the time of Jatra. Also, there was rain. My house faces to the east. Dandasi Behera, Ghana Behera, Laddu Behera, Bhaira Behera, and Kasi Behera are there. Houses to the south of my house. To the north of my house, one Narayana Behera has his house. To the west of my house, at the distance of 50 to 60 cubits, there is a street named Baurisai. There are intervening trees in between my body and Baurisai. Tuna was lying at a distance of 7 to 8 cubits from my backside veranda. I saw the culprits at a distance of 15 cubits. Seeing me, the culprits ran away. My brother-in-law was raising halla and Marigali. I and my wife raising halla as a kere rushed towards the body through the side of our house. My brother-in-law arrived at about evening, and at about 7:30 p.m., we all took our dinners and looking the house, we went to see the car festival without key. While Tuna slept on our backside length of my backside veranda will be 5 cubits, when breadth will be about 4 cubits. It is a fact. It is not a fact that my backside veranda is affected by rainwater. It is a fact that my brother-in-law was involved in a criminal case. It is a fact that I have not reflected in my affair the reason of discrepancy of the villagers and why they were against my brother. I did not remember if I had mentioned in my affair that my brother-in-law with his friends created disturbance.
So what is there to doubt this witness, sir?
Yes, my lord. Thereafter, your lordship may kindly say that statement they have not disclosed before the IO. before the IO, the statement of the PW1, the name of the appellant, they have not stated that he has seen the Narayana Patra. That statement has not confirmed before the IO. You'll also may see the entire IO statement. The cross-examination, you also.
Yes.
PW, running page 103, PW 9. I have seized the MO2 on production of paragraph 11.
1 minute.
I have not examined the SI RN, that's the previous IO. I have not examined the SI RN, that's who was the former IO on the question of seizure of MO2 from the spot. After seizure of MO2, I had kept the same in the PS Malkan. I have not mentioned in the seizure list exhibit 4/2 that after seizure of MO1, which has been seized, it was sealed by me. I have also not mentioned in the case diary regarding sealing of MO1. After it was seized by me, while sending both M1 and M2 to the professor, FMT Medical College, Barampur, for his opinion, I did not send it in a sealed cover. After seizure of M1, it was kept in police Malkhana. When all MOs were sent to the forensic laboratory through JMFC Kodala, all the MOs were sent in one sealed packet. I have not made any query to the Professor FMCT Barampur after seizure of MO2 on production by constables also about non-mentioning of opinion on the PM be possible by MO1. I did not made any inquiry to the FM about non-mentioning of his opinion of the PM report. Even though the dead body challan, though the dead body challan disclosed that MO2 was sent with the Your Lordship. This as the defective investigation. Your Lordship may kindly see thereafter. I have though paragraph 15 on the 105 page. I have issued command certificate, but I have not seized the same in this case. I have also not examined the special messenger who carried the affair of the affair to court. Thereafter, all the discrepancy. Thereafter, and I have not seen the photographer in the village when I arrived at the spot on the date of occurrence, though the IO was very much present on the spot, my lord.
No. So what is your comment on this witness?
Yes, my lord. So that witnesses has not stated before this IO that he has seen the present appellant standing on the spot.
So what? How does it make this deposition bad in law?
Yes, because there are some decision of the apex court, my lord.
No. This what is unbelievable about this witness PW1?
So far as the two eyewitnesses, one eyewitness PW2, the wife of the PW1, that stated that he has not seen he has not disclosed the name of the appellant. He has not disclosed the name of appellant, my lord. PW2, my lord, may kindly see.
No, but why should you disclose it to her?
Yes, my lord. They have not.
But why should he? Why should he disclose it?
My lord, the present appellant not assaulting, not holding any weapons, only standing. He has seen that. Nothing else.
That's not the evidence.
Your lordship, thereafter, your lordship may kindly see the PW7, my lord. PW8, my lord. The first IO. The PW8.
Yes.
Paragraph 7, my lord. Paragraph 7, my lord. Page 97. Cross-examination. There is no residential house of Ganavera near the place of occurrence, but he has his cattle shed. The distance between the cattle shed of Ganavera and the house of the profile of the informant, whose would be 70 feet. The spot is not visible. My lord, kindly important, my lord. It is important. The spot is not visible from the cattle shed, I Ghana Behera, and there is a obstacle implement. I have not seized any tangi, my lord. I have not the weapon, my lord. I have not seized any tangi. It is a fact that I have reflected on the dead body challan regarding sending one tangi to the doctor for opinion along with the dead body, my lord. But he has not seized any tangi, my lord. Your lordship, thereafter, paragraph 8, my lord. At 9:45 a.m., I had reached at the spot. OIC and Constable D.K. Swain were also present during my spot visit. At 9 a.m., OIC directed me to take up investigation, and thereafter I examined the informant before proceeding to spot. I have recorded 161 CRPC statement of the witnesses on 2 occasions. On 2 occasions, my lord, the first occasion they have not stated anything against the appellant. Thereafter, again 161 was recorded, my lord, by the IO from the PW1, my lord. One prior to 9:30 a.m. and the other 10:30 a.m. The informant was along with me till dispatch of dead body for postmortem. It is a fact that in the first 161 statement, informant recorded me. The informant had not disclosed before me categorically the name of the accused persons, Inna Behera and Tufan Behera, but had mentioned name of the son of Ramo Behera and a driver Patro. These 2 persons have been disclosed. First 161, but the present appellant name has not been disclosed.
They are sons of Ramo Behera. They are sons of Ramo Behera.
Yes.
Both are sons of Ramo Behera.
So the disclosed content. But I had name of the Ramo Behera. It is a fact I have not inquired as to how many sons Ramo Behera and driver Behera. It is a fact that I did not recorded the statement of Prafulla Behera at the spot. This spot was not recorded. The deposition, the statement was not recorded on the spot, my lord. I did not record Prafulla Behera. It is not a fact that informant had not lodged any report before OIC. I had examined the Grammaraki, though Grammaraki was available at the spot. It is not a fact that I had recorded statement of Grammaraki, but did not reflect in it the case diary. Case diary did not reflect any case diary. It did not suit to prosecution. It is a fact that informant had not stated before me that accused Narayana Patra standing at the spot.
This line is important to us.
No. Thereafter,
what had stated about Narayana Patra running away from the spot?
Not standing on the spot. It is a fact that Junna Behera had stated before me that her brother Tunna was involved in antisocial activities in the village and was outraging modesty of village girls. The deceased, my lord, outraging the girls, modesty of village girls, and also committing mischiefs by damaging electric bulb. The deceased, my lord, the activities of the deceased, my lord. It is a fact that I had inquired about the antisocial activities of the deceased and could gather from PS record that he had some criminal cases. That is the activities of deceased. My lord, the P11 has not stated before the IO that the present name of the present appellant, my lord. Nothing. And the tangi has not been seized and has been reflected in the challan report. The entire investigation is a defective investigation. Your lordship, another thing that the statement, all the witnesses are hostiles. All the witnesses except PW1, those are interested witnesses, and the brother-in-law of the deceased and
Yes, Mr. Katkia.
The eyewitnesses versions.
There's only one witness.
PW1 and PW2.
PW2 not disclosed.
What?
PW2 does not disclose the name of the accused.
Yes. So for Narayan Patra,
that's only one in the fray now.
That is paragraph, page 98. I was showing a lordship. Then in the middle portion, what my friend is submitting. that particular person has been confronted. So far as Narayan Patra is concerned, it is a fact that the informant had not stated before me about accused Narayan Patra standing at the spot, but he had stated about Narayan Patra running away from the spot. So his presence was very well noted. He was available there at the spot, along with others. As because other persons have not been named, so they have been acquitted. So this person was there, and he has been named in the FIR also, right from the beginning.
No, but is it safe? Only one person showing running away. Is it safe to base the entire conviction on that one small statement?
That part is admissible under section 6 and 7 of the Evidence Act. Because that person is available right from the beginning.
No, there could be so many bystanders. See, you don't know. Did they share the common intention? Now, if it is common intention, he was seen running away. He is not assaulting.
Yes.
Then, let's say he's one of the bystanders. He sees someone assaulting someone else. He's getting afraid and running away.
Can he be said to be a bystander here? In this case, right from the lodging of the FIR, plus I am reading that person. Also, I am translating it. Plus, seven Somaste all were there at Kotabadar and all ran away, throwing the weapon of offense Tangia. Then, in the moonlight, I could identify Narayan Patra. But in the beginning, right from the lodging of the FIR, Narayan Patra has been named.
No. He is saying this in court.
Yes.
Not in the FIR.
No, in the FIR also he has been named. Other persons have not been identified. So when both husband and wife went to the spot after
who's the informant? Who's the informant?
Informant is Prafula Behra, PW1.
So same man.
Same person.
He has not told the police that he saw Narayan Patra assaulting the deceased.
No, he has only told that he was running away. He has seen him running away.
So he's just naming one person, that's all. As running away, not as seeing as assaulting.
No, assault. He has not said.
All right. You see, this is an appeal directed against the judgment dated 21st March 2003, passed by the learned Second Additional Sessions Judge Berhampur in SC number 8 of 2002, convicting the present appellant for the offence under section 302, read with 34 IPC, for intentionally causing the death of one Tuna Behra on 2nd July 2001 in village Gaganapur in district Berhampur. Paragraph. At the outset, it requires to be noticed that there were 3 accused who were sent up for trial. The present appellant was accused number 1. The other 2 accused got acquitted by the trial court by the same impugned judgment. As a result, the present appellant has been convicted only for the offence under section 302 IPC and sentenced to imprisonment for life. Paragraph. By an order dated 16th March 2004, the appellant was enlarged on bail. Paragraph. This court has heard the submission of learned counsel to the parties. The case of the prosecution is that deceased Tuna Behra was staying in the last 2 years prior to his death in the house of his brother-in-law, Prafula Behra, bracket PW1, and his sister Junu Behra, bracket PW2, in village Gaganapur. Full stop. Tuna was running a grocery shop in the said village. Full stop. It is stated that the villagers were annoyed with Tuna for creating disturbances. And on 1st July 2001, 30 to 40 villagers got together and drove Tuna out. Paragraph. A village meeting was convened on the following day to resolve the issue. It was decided that at the meeting that a resolution could be arrived at only in the presence of Tuna. Full stop. On 2nd July 2001, when Tuna returned to the house of PW1, The decision of the village meeting was conveyed to him by PW1. Paragraph. It is then stated that at around 8 p.m. on 2nd July 2001, PW1 and PW2 left the home for viewing the car festival in the village. Stop. Deceased Tuna is said to have slept in the veranda in the rear side of the house after taking food. Paragraph. At 11 p.m. when PWs 1 and 2 returned, they heard Tuna shout, open quotation, Marigali, Marigali, from the rear side of the house. Full stop. When they proceeded to the rear side, they found 7 to 8 culprits assaulting the deceased by means of tangi and kati. Instead of seeing PWs 1 and 2, they fled away. Paragraph. The question is the precise identification of the present appellant Narayan Patra by PW1. Full stop. The trial court in the impugned judgment accepted the version of PW1 that he had identified the present appellant as one of the culprits. However, it is pointed out by counsel for the appellant that PW1, who is the only witness projected by the prosecution as an eyewitness, with all other witnesses turning hostile. What about PW2? Doesn't name.
Doesn't.
With all other witnesses, other than PW2 turning hostile. Cannot be viewed as being consistent or reliable. Full stop. Importantly, it is submitted that while PW2 did not name the appellant at all, it is only PW1 who is supposed to have identified him on the moonlit night of the date of the incident. However, it is pointed out that when the investigating officer (IO) PW10 was cross
8 and 9. 8
was cross-examined, he made an admission that open quotation, the informant had not stated before me about accused Narayan Patro standing at the spot, but had stated about Narayan Patro running away from the spot. Unquote. Paragraph. Mr. Katka Learned AGA also referred to the above statement and submitted that the presence of Narayan Patro was confirmed by the PW1 at the very first instance, even at the stage of registering the FIR, and therefore the evidence was sufficient to bring home the guilt of the accused. Paragraph. In the considered view of the court, the prosecution is on shaky ground as far as PW1 is concerned. Full stop. No doubt he is related to the deceased, but that has to put the court on caution as to how much of the deposition of the deceased should be accepted ipso facto. Full stop. It must not only be corroborated with medical evidence, but some other independent evidence that can lend assurance to the court about its veracity. Full stop. What is significant here is that PW1, in fact, does not, in the first instance, tell the police that the present appellant was one of the persons assaulting the deceased. Full stop. It becomes clear from the cross-examination of PW8 that the informant PW1 informed the IO only about the appellant running away from the spot, and not that the appellant was one of the assailants. Full stop. This is an important fact to bear in mind, particularly since the whole case of the prosecution was about 7 to 8 persons attacking the deceased with tangis and kati, and therefore roping in the present appellant along with 2 others with the help of Section 34 IPC. So, in other words, the whole case of the prosecution is about how all of these 7 to 8 persons shared the common intention of doing away with the deceased. So, that entire story has not been able to be established by the prosecution. Stop. In the first instance, it must be noted that even at the time of sending up the case for trial, there were only 3 accused out of the 7-8 persons who could be made to face trial. Full stop. Even of those 3, 2 got acquitted because of lack of evidence. Full stop. It is one thing to say that a person was present, was armed, and assaulted the deceased, and another to say such person was found running away from the spot. Full stop. Considering that the medical evidence shows how the deceased died due to attack by weapons, and the present appellant is not shown as possessing any weapon at all, but at the highest only found running away from the spot, in the considered view of the court, it would be unsafe to base the conviction of the present appellant for the offense under Section 302 IPC without the aid of Section 34 IPC, only on such weak evidence of PW1. Full stop. In other words, the evidence of PW1 is wholly insufficient to support the conviction of the appellant for the offense under Section 302 IPC. For all of the aforementioned reasons, the court is of the view that the benefit of doubt ought to be given to the appellant. He is accordingly acquitted of the offense under Section 302 IPC. The impugned judgment of the trial court is set aside. The bail bonds furnished by the appellant stand discharged. You continue after lunch. All right. Yes.
Vehicle list item number 5.
Item 5, there's an order, my lord, dated 23/8/2013, wherein this honorable court was pleased to direct the Secretary High Court Legal Service Authority to engage a lawyer, my lord. As it appears from the list, my lord, Miss Sadha Lakshmi Patnaik has been engaged probably.
Where is she?
I'll inform her, my lord.
Please ask her to come. No? So which matter is yours?
Item 6.
Come. Please come.
Item 6.
Yeah,
Item 6. My lord, the appellant is the elder brother of the deceased.
Okay.
already spent 13 years jail custody, my lords.
All right.
So, my lords, bail application may be considered.
No. You argue the matter, sir. You argue the matter.
No, intentionally murdered him, killed him. Prosecution case is, my lords, the accused Gondaram Bag, the elder brother of the informant, husband of the informant Nilapati Bag, used to quarrel with the informant for husband and villagers were influence of liquor on 11/5/2009 at about 12 noon. Thereafter, he was quarrel between Gunadevibag and received mailers and accused on that night about 8:30 p.m. Accused suddenly out of previous grudge inflicted X blow at the head of the deceased, for which he fell down facing upwards. Thereafter, the accused was assaulted by X at his chest. At that time, Gutpeshwar Bag caught hold of the accused, and Noto Bag, the nephew of the informant, snatched away the axe from the accused. While snatching away the axe, the accused had also assaulted Gutpeshwar Bag with the handle of the tangia with intent to kill him. Subsequently, the injury Gunodhi was shifted to hospital. There was the doctor declared him dead. Thereafter, the informant lodged the FIR.
So let us read PW1, sir.
Yes. Page 30.
My lords, PW1, Nilavati Bag informant. I know the accused standing on the dock. I am the informant of this case. On 11/5/2009 at about 9 p.m. The
8 p.m.
My lords, the occurrence took place. The accused Gonarabag quarrel with my husband and went away. The accused is the brother of my husband. While I was serving rice to my husband in our courtyard, the accused came along with an axe and inflicted 2 blows at the head of my husband, for which my husband fell down, sustaining bleeding injury. Thereafter, the accused also inflicted 1 axe blow on his chest by the sharp side of the axe, causing bleeding injury. Thereafter, Gitanjali and Noto Bag and Gutpeshwara Bag, who are the daughter, son, and brother-in-law of the accused, came and caught hold of his. We took my injury sustained to Saintala Hospital, where the doctor declared him dead. There, I went to the Saintala PS and presented a written report marked Exit 1 is my signature. I get FIR scribed through the Sarvasiddhi Rana. Sarvasiddhi Rana, after scribe of the FIR, read over and explained its contents to me, and then I signed email. It was examined by the police.
What do you have to say, sir? What about the cross-examination? Is there anything there?
No, madam. Rather, it suggests there was previous enmity and they used to fight earlier, and he always, under the influence of alcohol, used to abuse. 5 eyewitnesses, madam. 1, 4, 7, 9, 11.
Yes, sir.
All are evidence against the accused man.
Correct.
Only 30 years.
Paper book. The present appeal is directed against an order dated 13th December 2010, passed by the Additional Sessions Justice Lagar in SC case number 147 of 2009, convicting the appellant under section for the offence punishable under section 302 IPC and sentencing him to undergo rigorous imprisonment (RI for life) and to pay a fine of rupees 5,000 and in default to undergo RI for 2 years. Paragraph. The case of the prosecution is that the accused Gandharam Bagh, alias Kita, used to quarrel with the informant Neelapati Bagh bracket PW1 and her husband Gunanidhi Bagh bracket the deceased and other villagers under the influence of liquor. Stop. It is stated that around 12 noon on 11th May 2009 also there was a quarrel between the deceased and the accused. Stop. That night at around 8:30 p.m. while the deceased and PW1 were eating rice sitting in the courtyard of their house, and Gupteshwar Bagh bracket PW11, the brother-in-law of the deceased, was talking with him sitting on a cot, suddenly the accused, who is the elder brother of PW11, who's the elder brother of the deceased, came with an axe, bracket Tangya, and out of a previous grudge, inflicted an axe blow on the head of the deceased, who fell down facing upwards. Thereafter, the accused again assaulted the deceased on his chest with the axe. At that time, PW11 caught hold of the accused, and Nita Bagh, bracket PW9, bracket the nephew of PW1, snatched away the axe from the accused. The accused had also assaulted PW11 with the handle of the Tangya with an intent to kill him. Subsequently, the deceased was shifted to the Saintala hospital where the doctor declared him dead. Paragraph. Upon completion of investigation, a charge sheet was laid against the accused who pleaded not guilty and claimed trial. The case of the defense, as spoken by the accused who examined himself as DW1, was at around 8 p.m. He was along with the deceased bringing firewood by loading it in a bullock cart, and the deceased was sitting on the cart. The bullock cart entered into a ditch. He fell down and the Bullock cart and the firewood also fell on him, for which he sustained bleeding injuries on his head. Semicolon. Subsequently, he was taken to the hospital where the deceased died. Paragraph. The prosecution examined as many as 21 witnesses, of which PW's 1,
4, 7, 9, and 11 are eyewitnesses.
4, 7, 9, and 11 were eyewitnesses. Full stop. PW1 was the wife of the deceased. PW4 was the niece.
PW4 and 7 are daughters.
PW4 and PW7 were the daughters
9
of the
is the
deceased.
son.
9 was the son of the deceased. And 11 the brother-in-law of the deceased.
And 11 is my brother-in-law.
The brother-in-law of the deceased. Full stop. No, he's the brother of the wife, I think. Yeah, he's the brother-in-law of the deceased. The medical evidence of PW13, Dr. Brajendra Panda, revealed the presence of the following injuries on the dead body of the deceased. A to A. The injuries were stated to be ante-mortem injury in nature and could have been caused by a sharp weapon. Cause of death was due to injury to the vital organ like brain. The doctor confirmed subsequently that the injuries could have been caused by the tangia that was seized from the spot. He denied the suggestion that the injuries could have been caused by fall on a sharp object. Full stop. The trial court, on an analysis of the evidence, was convinced that the prosecution had brought home the guilt of the accused beyond all reasonable doubt. This court has heard the counsel for parties. It has also been taken through the evidence. Stop. The eyewitness testimony of PW1 is clear and cogent about the actual assault, as she was witness to it from a distance of just 3 to 4 feet. Stop. Corroborating her were her own son and daughters and her brother, PW11. Full stop. The fact that there was a previous quarrel at around 12 noon between the accused and deceased, and that the accused was under the influence of liquor has also been sufficiently established. Full stop. When the accused returned to the house of the deceased with the tangya, he walked stealthily through a lane, inflicted one blow on the by the sharp side of the axe, and when the deceased fell down, he inflicted one blow by the blunt side of the axe on the chest. Paragraph. From the evidence of PW4, it is also clear that PW11 and her brother Natabag, PW9, caught hold of the accused, and that PW9 snatched away the axe from the accused. And thereafter, accused fled away through the single quotes bari bracket, close quotes side. Stop. PWs 7 and 9, the daughter and son of the accused, of the 7 and 9 are daughter and son of the accused.
Yes. No, they're
4 and 7, my lords.
4 and 7 are the daughters, madam.
No, not of the deceased, right?
No, madam. Accused.
Oh.
Yes. They were staying with the paternal
family.
uncle. Yes.
Fact. It's a significant fact that PWs 4 and 7 are the daughters of the accused himself, and they were all living as a joint family, and they have fully supported the prosecution. Paragraph. The accused who examined himself as DW1 tried to project the entire incident as an accident of the accident in which a bullock cart full of firewood overturned on the deceased, as a result of which he sustained bleeding injuries. TW1 further stated that his son Nata Bag, bracket PW9, Gupteshwar Bag, bracket PW11, and Nilabati Bag, bracket PW1, had also gone to the hospital with the deceased. So, however, none of these witnesses came up with any such theory and did not support the accused at all. The trial court rightly therefore disbelieved DW1. DW1 also tried to project that they took the injured deceased to the hospital, and Dr. Namita Bishi, bracket PW19,
Item 5, my lord.
gave him a saline injection. However, PW19 was examined and did not state anything about giving injection and saline to the deceased at the hospital. On the other hand, she states that he was brought dead to the hospital. The entire evidence of the prosecution establishes beyond reasonable doubt guilt of the accused for having murdered his younger brother out of a previous quarrel. Stop. The court is unable to find any infirmity in the impugned judgment of the trial court, convicting and sentencing the accused in the manner aforesaid. The appeal is accordingly dismissed. The bail bond, there's no, he's still in jail only, right? All right. No other is to cause.
Weekly list item number 5.
Item 5, my lord.
Yes.
In this case, my lord, this matter may be taken up after vacation, my lord. Since I was in the hospital, my lord, I could not prepare myself, my lord.
Just stay on board. All right, please stay on board, madam. Yes.
Weekly list item number 7.
Lordship, item number 2.
Yes.
Item number 2.
Yes, please.
Item 2.
Wait, 1 second, Lordship.
May I please, your lordship?
Yes.
Item 2 has been adjourned. The lordship has asked to call for the whereabouts. Yes, on the first half, it is Apollo.
No, we said it will stay on board.
Please, your lordship. This is a matter, your lordship, it is filed on 13th May. This is a pattern to your lordship. There is Puri Jagannath Mandir and your lordship already.
No. Sorry, sir. We are on old matters.
Oh, I'm sorry, your lordship.
Item number 7. Weekly list item number 7, JCRLS 7 of 2011.
He was released on bail on 28 January 2020. Very recently.
Yes, boss. 28th January 2020. 28th January 2020.
None appears for the appellant. Notice without process fee be served upon the appellant to the concerned IAC to ensure his presence in court in the next date. Meanwhile, a complete copy of the paperwork be furnished to the Secretary, Orissa High Court Legal Services Committee, bracket OHCLSC, for being served, interested to a panel counsel of not less than 10 years experience to appear for the appellant. The panel counsel will get in touch with the appellant before the next date. Listen, 22nd July.
Weekly list item number 8.
Case of eyewitness, 2 eyewitnesses, PW7 and PW8. And motive was also there, previous quarrel.
But he's still in jail, I think. No bail has been granted.
Yes.
No? You see the complete, none appears for the appellant. The complete set of the papers being provided by the registry to the secretary over CLSE for being entrusted to a lawyer of not less than, panel lawyer of not less than 10 years experience. The panel lawyer on the strength of this order can establish contact with the appellant in jail and seek instructions. 22nd July.
Weekly list item number 9.
There's also a jail criminal appeal. As it seems from a record, my lord, he is not on bail.
He's not on bail.
No, my lord.
Okay.
Must
Similar
be
order in 9 notes.
Same date.
Same date.
Weekly list item number 10. Then the appellant has been released on bail on 2nd May 2018.
We say notice of process fee, same order to the appellant through the IAC of the concerned police station. Require him to remain present in court on the next date. Then that whole part handing over to the OHCLSC. List on 29 July. Sorry, make it 21st and 28th Thursday. The earlier 22nd will be 21st. And this will be 28th. Wherever it said 29th to be 28th. Thursday. It has to be a Thursday. All right.